Yes, thank you, Mr. Speaker. I'm rising with respect to the notice of a question of privilege, which I provided to you under Standing Order 48 concerning the third and final report of the Special Joint Committee on the Declaration of Emergency, which was tabled in the House of Commons earlier today. In brief, when the member from Eglinton, Lawrence, then the Minister of Public Safety, appeared before the committee on April 26th of 2022, he made repeated assertions that the NDP-Liberal government invoked the Emergencies Act at the request of law enforcement. This now infamous claim by the former minister, made at the committee table, went viral.
I believe a point of order, the honourable member for New Westminster Burnaby.
Thank you, Mr. Speaker. It's always important to question a privilege. It's important to be factually correct. The minister wouldn't have referred to the NDP-Liberal government, and so I would ask through you that the member respect the rules around a question of privilege and stick with the facts.
I appreciate the honourable member's intervention on that, and I will again just remind those who are presenting points of privilege here to be factual and, of course, as efficient as they can with the time they have before them, and stick to the facts themselves. The honourable member for Medicine Hat, Carson Warner.
Thank you, Speaker. This now infamous claim by the former minister, made at the committee table, went viral as police officer after police officer and official after official denied it before the committee, the Standing Committee on Procedure and House Affairs, and the Public Order Emergency Commission. Documentary evidence further substantiated just how wrong the former minister's claim was. With all reports from all three bodies now formally before the House in the present session, the House is seized with irreconcilable claims for which the air must be cleared. As you know, it is a contempt to mislead the House of Commons or any of its committees. I will therefore argue that the member from Eglinton, Lawrence, deliberately misled the Special Joint Committee, giving rise to a prima facie contempt. The committee's third report details, in the first paragraph of the justification section of Chapter 7, under the invocation of the Emergencies Act, the former minister's evidence to the committee on April 26 of 2022, and I quote, "Some witnesses before the committee cited the public safety concerns as justification for a Cabinet's decision to invoke the Emergencies Act. For instance, the former minister told the committee that the federal government received advice that law enforcement needed the Emergencies Act to be sure that they would resolve, for example, ambiguities around those who were staying close to ports of entry. He reiterated that we invoked the Act because it was the advice of nonpartisan professional law enforcement that existing authorities were ineffective at the time to restore public safety." End of quote. For good measure, Mr. Speaker, the former minister's other comments to the committee that night include the following, and I quote, "The government remained engaged with further enforcement throughout to ensure that they had the support and the resources they needed. However, when efforts using existing authorities proved ineffective, the advice we received was to invoke the Emergencies Act." End of quote. He went on to say, and I quote, "The advice we were getting was that law enforcement needed the Emergencies Act." End of quote. He also was stated as saying, and I quote, "As we took our decision in what we could do to respond, we were following the advice of various levels of law enforcement, including the RCMP and commissioners." End of quote. Now that last quote is particularly important, bearing in mind what the committee reported, beginning at the 10th paragraph of the section on cooperation among different levels of policing found in Chapter 5, Police Response to the Freedom Convoy, and I quote from that report, "There is evidence to suggest that police leadership had exhausted all available tools to bring the protests and blockades to their conclusion when the federal government decided to invoke the Emergencies Act. At the Public Order Emergency Commission, a 14th of February 2022 email from then Commissioner of the RCMP, Brenda Luckie, to the Chief of Staff to the former minister stated, and I quote, "This said, I am of the view that we have not yet exhausted all available tools that are available through the existing legislation. There are circumstances where charges could be laid under existing authorities for various criminal code offences occurring right now in the context of the protest. The Ontario Provincial Emergencies Act just enacted will also help in providing additional deterrent tools to our existing toolbox. These existing tools are considered in our existing plans and will be used in the due course as necessary." End of quote. I want to pause here for a moment, Speaker, to note three things. First, on September the 22nd, 2022, the committee adopted a motion with a view to achieving efficiencies in its own proceedings to, and to quote the report, "deem the evidence, including testimony and documents received by and published on the websites of the standing committees of the House of Commons and the Public Order Emergency Commission in relation to the February 2022 public order emergency and matters consequential to it, to have been received by this committee and may have been used in its reports." End of quote. Secondly, as we know from the Relu Commission records, the former minister's chief of staff forwarded the RCMP commissioner's message directly to the then minister. The email is Relu Commission document Sierra Sierra Mike SSM NSC CAN 0000228. And thirdly, Commissioner Lucky's statement about not exhausting all available tools was actually emboldened to attract the attention of the minister's eye with red lettering. So it's clear, Mr. Speaker, that the member from Eglinton Lawrence was put on clear notice that invoking the Emergencies Act was not the RCMP's advice, in sharp contrast to what he had claimed at the committee table. Now, going back to the third report, picking up 4 paragraphs later, we read, and I quote, "Then Ottawa Police Chief Peter Solly told the committee that the Ottawa Police Service had a plan ready to clear downtown Ottawa, and that the Ottawa Police Service maintained control of the plan during his tenure as the Chief of Police." End of quote. Now, his tenure ended the day after the Emergencies Act was invoked. Mr. Solly testified before the committee on October 6, 2022, and is quoted on page 3 of the evidence saying, and I quote, "There were no explicit conversations that I had with other levels of government regarding declarations of the Emergencies Act at all 3 levels." End quote. He then immediately clarified this, adding, and I quote, "We did have conversations with the City of Ottawa around their emergency, but not the other 2 levels of government." End quote. Other witnesses before the Special Joint Committee also testified that they had not requested the invocation of the Emergencies Act. Then RCMP Commissioner Brenda Lucki is quoted on page 10 of the evidence for May 10th of 2022 saying, and I quote, "No, there was never a question of requesting the Emergencies Act." End of quote. When pressed to confirm that statement, if she ever asked for the invocation of the Act, she firmly answered, "No." End of quote. The then Emergency Preparedness Minister, now the Minister of National Defence, testified on June 14th of 2022 at pages 22 and 23 of the evidence that he had not heard any advice or request from the police asking for the invocation of the Emergencies Act, adding, and I quote, "Quite frankly, I would have been quite surprised, if the police had actually made a policy recommendation or asked for any legislative authority." End of quote. On October 26, 2022, then Ottawa Mayor Jim Watson confirmed at page 14 of the evidence that he had not sought any emergency declarations. On November 3rd of 2022, Ontario Police Commissioner Tom Korik confirmed at page 17 of the evidence, and I quote, "I can tell you that I am telling you the absolute truth, sir. At no point did I provide or request that Emergencies Act be invoked." End of quote. He then added, and I quote again, "I did not provide any advice of that nature, nor am I aware of anyone from my legal team providing such advice." End of quote. Those statements alone, Mr. Speaker, show that there was irreconcilable evidence before the committee, which has now been reported to this House. But the concern just doesn't stop there. In parallel to the Special Joint Committee's work, our Procedure and House Affairs Committee was conducting its own study of security arrangements on or near Parliament Hill, hearing from a number of pertinent policing and security witnesses who appeared in the aftermath of the former minister's famous claim. The evidence which it heard was reported to the House in that committee's 19th report, tabled on December 14th of 2022. Firstly, on page 13, we read the former minister's own take, and I quote, "During the appearance by the then Ministers of Public Services and Procurement and Public Safety, some members of the committee asked questions about the invocation of the Emergencies Act. In particular, it was asked which police agency asked for the Emergencies Act to be invoked. In response, the member for Eglinton, Lawrence, stated that there was a very strong consensus among law enforcement that the Emergencies Act was necessary, as stipulated in the letter from the Canadian Association of Chiefs of Police." End of quote. Then, turning to page 23 of the 19th report, we see, and I quote, "When asked about the invocation of the Emergencies Act by the federal government, then interim Ottawa Police Chief Steve Bell stated that the Ottawa Police Service, had had conversations with its partners and political ministries, but did not directly request that the Act be invoked." Chief Bell later testified before the Special Joint Committee on November 3rd of 2022 at page 2 of the evidence that, and I quote, "No, we never made a direct request for the invocation of the Act." End of quote. Later in that same meeting, at page 9, he confirmed, and I quote again, "That's correct. There was no direct request made from the Ottawa Police Service." End of quote. Now let's go back to the Procedure and House Affairs Committee's 19th report. We read on page 26, and I quote, "Asked whether the service of the police service of Gatineau was able to manage the disruptions in Gatineau caused by the Freedom Convoy, Service Director Luc Beaudoin indicated that it was able to do so, in particular thanks to the collaboration of its partners and the Coordination Center." End of quote. Moving to page 29, we learn, and I quote, "When asked if the Parliamentary Protective Service had requested the invocation of the Emergencies Act on February of 2022, Service Acting Director Superintendent Larry Brookson answered no. He noted that there was no benefit whatsoever in the invocation of the Emergencies Act for PPS because it is not a policing organization, so it received no additional powers through the Act." End of quote. I would pause here, Mr. Speaker, to add that Superintendent Brookson confirmed this evidence for the Special Joint Committee during his appearance there on September the 29th of 2022 at page 10 of the evidence. Mr. Slowly, the former Ottawa Police Chief, had also appeared before the Procedure and House Affairs Committee, which reported at page 37, and I quote, "He did not ask the federal government to invoke the Emergencies Act. He was not aware of anyone making that request within the Ottawa Police Service." End of quote. The then city manager of the City of Ottawa, Steve Kanellakis, was also a witness. And the 19th report, page 48, states, and I quote, "Mr. Kanellakis was asked by the committee whether the Ottawa Police Service had requested the invocation of the Emergencies Act. In response, he stated that he was not aware of any such request." End of quote. Mr. Kanellakis also said in his opening statement to the Special Joint Committee on October 26, 2022, at page 3 of the evidence, and I quote, "To my knowledge, the city never requested the invocation of the Act." End of quote. Next, Speaker, let's turn to the report of the Public Order Emergency Commission, which was tabled in this House on February 17, 2023, as sessional paper number 8530-441-17. First, on page 115 of Volume 1, Commissioner Rouleau wrote, and I quote, "A question that arose during the Commission's hearings was whether Cabinet was advised of Commissioner Lucky's view that not all existing tools had yet been exhausted in Ottawa. She had expressed this view to the former Minister's Chief of Staff less than an hour before Cabinet meeting began, but this was not passed on to Cabinet." End of quote. Later, the Commissioner expanded upon this at page 92 of Volume 3. A question that arose during the Commission's hearings was whether Cabinet was advised of Commissioner Lucky's view that not all existing tools had yet been exhausted in Ottawa. Less than an hour before the Cabinet meeting began, Commissioner Lucky responded to an email request from the former Minister's Chief of Staff, Mike Jones, for a list of emergency measures that might assist law enforcement in bringing the protests under control. Commissioner Lucky suggested a number of tools, but added that, in her view, all of the tools available through existing legislation had not yet been exhausted. She noted that there were instances where charges could be laid under the criminal code, and that Ottawa's recent declaration of emergency would also help in providing additional tools. Mr. Jones forwarded Commissioner Lucky's email to the former minister and then Deputy Minister of Public Safety, Deputy Minister to Public Safety, Robert Stewart, half an hour before the Cabinet meeting began. The comment about the sufficiency of existing tools was not incorporated into the speaking notes that Commissioner Lucky sent to the former minister. And the then National Security and Intelligence Advisor to the Prime Minister, Jody Thomas, a few minutes before the start of the meeting. End of quote from the Commissioner's notes. In addition to these three reports, Mr. Speaker, the former minister testified to the Special Joint Committee is also contradicted by the government's response to order paper question number 613, signed by the then minister's parliamentary secretary. Through this written question, the government was asked, and I quote, "With regard to the government's invocation of the Emergencies Act earlier this year, did any police force make a request for the Act to be invoked? And if so, what are the specific details of any such requests, including which police forces submitted that request and on what date each such request was received by the government?" End of quote. The then Parliamentary Secretary response danced around the heart of the question, but she nevertheless answered, and I quote, "The RCMP did not request for the Act to be invoked." End of quote. And she reiterated that quote with again, and I quote, "With regard to the RCMP, the Royal Canadian Mounted Police did not make a request for the Act to be invoked." End of quote. All in all, Mr. Speaker, the former minister's claim to the Special Joint Committee found in its report, which is now before the House, has been flatly contradicted by all other evidence on the question before the House. Now, the House of Commons Procedure and Practices, 3rd edition, at page 81, provides a list of established grounds for contempt, including, and I quote, "deliberately attempting to mislead the House or committee by way of a statement, evidence, or petition." End of quote. This point is reiterated again at page 112. For its part, United Kingdom House of Commons Committee on Privileges has also recently considered the matter of a minister misleading Parliament. That committee's 5th report, tabled in June of 2023, notes at paragraph 6 that, and I quote, "misleading intentionally or recklessly, refusing to answer legitimate questions, or failing to correct misleading statements impedes or frustrates the functioning of the House and is a contempt." End of quote. The importance of accurate information being provided to Parliament has been underscored in a number of rulings in this House, including your predecessor on March 3rd of 2014 at page 3430 of the debates. It states, and I quote, "This incident highlights the primordial importance of accuracy and truthfulness in our deliberations. All members bear responsibility, individually and collectively, to select the words they use very carefully and to be ever mindful of the serious consequences that can result when this responsibility is forgotten." End of quote. The United Kingdom Privileges Committee, meanwhile, explained at paragraph 8 of its 4th report, tabled in March of 2023, that, and I quote, "the expectation is that when the House hears from ministers, what it hears is the truth as far as the minister knows it. The House considers legislation and scrutinizes government activity on the basis that what it is told is accurate. Parliament expects and requires proactive candor and transparency. This is what is necessary for the House to do its job properly. If a minister makes an inadvertent error, they are expected to correct it at the earliest opportunity. Mistakes inevitably happen, and corrections are made routinely. The more important the issue, the more seriously the House will take any questions of misleading." End of quote. There is a well-established test for determining whether deliberately misleading information has been provided, which, for example, you explained in the February 15th, 2024 ruling at page 21158 of the debates. And I quote, "It must be proven that the statement was misleading. It must be established that when making a statement, the member knew it to be incorrect, and finally, it must be demonstrated that the member intended to mislead the House. End of quote. In the circumstances, Mr. Speaker, I would respectfully submit that all three branches of this test can be made out. First, the overwhelming body of evidence, in fact, basically every source of evidence other than the former minister himself, which I have already quoted, contradicts the former minister. There can be no reasonable conclusion other than the fact that the former minister's statement to committee was misleading. Secondly, the email from the then RCMP commissioner to the former minister's chief of staff, who in turn forwarded it to his boss, makes it quite clear that the former minister was on notice of the actual opinion of the country's top cop. In the face of it, how could he plausibly claim that law enforcement actually made the request? And thirdly, Mr. Speaker, the context of the former minister's comment and trying to manage concerns regarding an extraordinary assertion of legal powers by the federal cabinet in response to a protest against its policies is one which goes to explain the likely intention behind it, to syndicate the responsibilities for such a controversial decision onto the shoulders of non-political institutions like the police and away from the political actors who actually took the decision. In any event, intention is not something which I would respectfully submit requires, at this stage, ironclad proof, like a confession. Indeed, the Procedure and House Affairs Committee, at paragraph 15 of its 50th report, presented in March of 2002, explicitly acknowledges that intention may well be a matter for committee investigation. And I quote that particular report. As the then Clerk of the House, William Corbett, explained to the committee, it is not uncommon for inaccurate statements to be made in the course of debate or question period in the House. This issue is whether the statements were made deliberately with the intent of misleading the House or its members. In the case where a member later admits to having knowingly provided false information, as in the Profumo case, the issue of intent is clear. In the absence of such an admission, however, it rests with the committee to examine all of the circumstances and determine whether the evidence demonstrates an intention to mislead. End of quote. The Procedure and House Affairs Committee continued in the same vein at paragraph 39 of the same report, noting that at times inferences must be drawn to establish intent. And I quote that report again. Intent is always a different element to establish in the absence of admission or confession. It is necessary to carefully review the context surrounding the incident involved and to attempt to draw inferences based on the nature of the circumstances. Any findings must, however, be grounded on facts and have an evidentiary basis. End of quote. At Westminster, meanwhile, the Privileges Committee, in its fourth report, wrote at paragraph 6, and I quote from that particular report, if a statement was misleading, we will consider whether that was inadvertent, reckless, or intentional. If we conclude that it was in any way reckless or intentional, we will consider what sanction to recommend to the House. It will be for the House to decide whether to accept or reject our conclusions and recommendations. End of quote. It might also be worth noting here, Mr. Speaker, citing the related footnote in footnote 4 of that report, and I quote, we emphasize that the committee is not a court of law. It is a select committee of Parliament, and its processes are parliamentary rather than forensic. The committee will adopt plain English definitions of key concepts as used in a parliamentary context. End of quote. The Parliamentary Privilege in Canada, second edition at page 234, explains, and I quote, before the House will be permitted by the Speaker to embark on a debate in such circumstances, it must be demonstrated that a member of the House of Commons was intentionally misled or an admission of the facts that leads naturally to the conclusion that a member was intentionally misled. End of quote. The long list of contradictory evidence, which I suggest lead naturally to the very strong inference, is not the conclusion that the Special Joint Committee was intentionally, I'll read that again, Speaker. The long list of contradictory evidence would, I suggest, lead naturally to the very strong inference, if not the conclusion, that the Special Joint Committee was intentionally misled. Next, Speaker, I wish to address another matter concerning this question of privilege, namely the requirement to rise in a timely manner. On first blush, raising a concern about something which was said over 31 months ago would not be considered timely. However, since it happened in a committee, the clock only started from the moment the third report was tabled in the House, which was this morning. It would have been premature to have raised this concern any sooner. As Mr. Speaker Reagan said on September 27th of 2016 at page 5175 of the debates, and I quote, "The Speaker cannot pass judgment on matters that are not properly before the House. The authority of the Speaker is limited to studying evidence before the House, such as statements made in the House or matters detailed in reports from committees, and not evidence gleaned from other sources." End of quote. Your immediate predecessor held on May 11th of 2021 at page 7023 of the debates, and I quote, "There is no precedent where the chair has used testimony from a committee without there being a report on the subject." End of quote. This rationale was more fully elaborated by Speaker Milliken on February 10th of 2011 at page 8030 in a comment quite relevant to the present case, given the former minister's wild claim became a matter of considerable discussion on the floor of the House. And I quote from that particular ruling. "The chair was limited in its ability to act on the full range of that review, since much of the proceedings referred to in member submissions were never officially placed in the hands of the House." The Parliamentary Secretary to the Government House Leader was not mistaken in his assertion that any and all statements made in committee, even when there have been repeated verbatim in the House, remain the business of the committee until such time as it elects to report them officially to the House. It may sound overly technical, but the reality is that when adjudicating cases of this kind, the chair is obligated to reference material fully and properly before the House. End of quote. But now, the information is fully before the House and squarely before the House in the form of the third report, the Procedure and House Affairs Committee's 19th report, the Reload Commission's report, as well as the order paper question response, which I quoted. We are now faced with the concern expressed by one of your predecessors on March 3rd of 2014 at page 3430 of the debates, and I quote, "At the same time, the fact remains that the House continues to be seized of completely contradictory statements. This is a difficult position in which to leave members, who must be able to depend on the integrity of the information with which they are provided to perform their parliamentary duties." End of quote. In that case, the chair found a prima facie case of privilege, just as Speaker Milliken did on February 1st of 2002 at page 8581 of the debates when he said, and I quote, "The authorities are consistent about the need for clarity in our proceedings and about the need to ensure the integrity of the information provided by the government to the House. Furthermore, in this case, as honourable members have pointed out, integrity of information is of paramount importance, since it directly concerns the rules of engagement for Canadian troops involved in the conflict in Afghanistan, a principle that goes to the very heart of Canada's participation in the war against terrorism. In deciding on alleged questions of privilege, it is relatively infrequent for the chair to find prima facie privilege. It is more likely that the Speaker will characterize the situation as a dispute as to facts. But in the case before us, there appears to be, in my opinion, no dispute as to the facts. I believe that both the Minister and the honourable members recognize that the two versions of events have been presented to the House. On the basis of the arguments presented by honourable members and in view of the gravity of the matter, I have concluded that the situation before us, where the House is left with two versions of events, is one that merits further consideration by an appropriate committee, if only to clear the air." End of quote. At the same time, or the same motivation to clear the air also inspired another prima facie finding by the chair in March 9th of 2011, as well as the 2014 case, as I cited. Now, while the present circumstances do not relate to Canadian participation in conflict abroad, they do relate to the justification for the invocation of the Emergencies Act. a decision which allowed Cabinet to legislate without regard to the authority of Parliament or to the usual constitutional divisions of power. A decision of this magnitude must be supported with clarity and integrity of information, just as Speaker Milliken had insisted concerning the deployment of JTF-2 soldiers in Afghanistan. Speaker, I would submit that the necessary thresholds have been made out here, allowing for you to make a prima facie finding. In order to allow for the air to be fully and properly cleared, I intend to propose referring the matter to the Procedure and House Affairs Committee so that we might get a definitive response, a report on the issue. In conclusion, Mr. Speaker, Parliament deserves to receive clear and definitive answers to questions. It must be entitled to the truth. On a matter about sidelining Parliament's own legislative and constitutional authority, the stakes are even higher. That is why I urge you to find a prima facie case of privilege in relation to the member for Eglinton Lawrence and his testimony to the Special Joint Committee on the declaration of emergency, for which I am prepared to move an appropriate motion. Thank you, Mr. Speaker.